So after these two very interesting presentations, I propose to talk about the cessation of effect of the priority national patents now that the UPC is launched. And as you will see, the legal framework has changed as of June 2023, and we'll see now how. So as I said, I will present what changes in national laws as of June 1st, 2023, during and after the transitionary period on the fate of the national patents that are priority patents for European patents. As all of you know, when the European patent is granted on the same invention, benefiting of the same priority date and for the same applicant, the national priority patent has two different fates depending on the countries in the EPC country. For a number of countries, the national patent will remain valid or remained valid before June 1st, 2023 and unenforceable. And so there was double protection between the national priority patent and the European patent. And it was the case in Austria, Denmark, Finland, Sweden, Slovenia, and Portugal. And in other countries, namely in Italy, France, and Germany, and the Netherlands also, the national patent became invalid and non-enforceable as soon as the European patent gets definitely granted, meaning as soon as the opposition period or proceedings was over. That was before the UPC was launched, and now, as you know, it is possible for the European patents to become a unitary patent. And in this case, the UPC will get the exclusive jurisdiction over this European patent with unitary effect. And the national jurisdiction remain competent only for the national priority patents. And so in this case, you have two different titles that are handled by two different courts, the National Court for the priority patent and the UPC for the unitary patent. On the one hand, this can lead to third parties having to handle two independent actions to invalidate the two different patents. And it may happen that contradictory judgments can be pronounced, and that may lead to insecurity of third parties. On the other hand, if double patenting is not allowed, then there would be only one European patent, the unitary patent, and that can be challenged and revoked in all UPCN countries in one time. So this will be a big risk for the patentee. So the possibility of double protection in this novel situation had to be reassessed, and unfortunately the EU regulations didn't address this question. So all the countries had to choose what to do, and they did not the same, as we will see now. So 5 countries have changed their laws to become double patenting friendly. So Italy, Germany, and France, for example, they were double patenting refractory, and now when the European patent is a unitary patent, it is possible for the national priority patent to remain alive, valid, and enforceable. And this is a huge change, because now the national Italian, German, and French national patents can still be challenged, even if the European patent exists and is a unitary patent. Other countries didn't change their law, and that are the countries where double patenting was prohibited, and in particular in the Netherlands. So that doesn't change, even if unitary effect is requested for the European patent. And for the other countries where double patenting was possible, it is still the case in Austria, Denmark, and so on. So now what happens during the transitory period where you know that the classical patent without any unitary effect can be handled by both courts, the UPC or the national courts. For these particular patents, 2 countries have decided to allow the double patenting of, and so to maintain the national priority patent alive, because UPC may have the jurisdiction over the European patent. So in France and Germany now, when the patent has not been opted out and when the has no unitary effect, there is no cessation of effect for the national priority patent. This applies only for when the European patent has been granted after June 1st, 2023, or was granted before, but the opposition period or proceedings were not ended at this date. And also during this transitory period, the patent can be opted out, as you know, and in this case, the UPC can't PC it anymore. And for all the countries that change their laws, it's not possible to have the national priority patent coexisting with an opt-out European patent. And this is the same as before, and the opt-out registration will make the national patent cease its effect. So if the opt-out is registered after opposition is closed, opposition period or proceedings, then the national patent will become enforceable as soon as the opt-out is registered. And if the opt-out is registered before the opposition is closed, then the priority patent will become unenforceable as soon as the opposition period is closed. And after these 7 or 14 years of transitional period, as you all know, the UPC will become exclusively competent for all the European patents, and there will be no opt-out possible. So in this case, the fate of the national patent will depend on the country, as we mentioned, and we have to remind that in 3 countries, Italy, Estonia, and Malta, the fate of the national patent will depend on the unitary effect of the European patent. I will not go into more details because it's a summary of what I said before. Just to remember that the double patenting, the countries where double patenting is possible allow a safety net in case the unitary patent is revoked centrally. And also, it may happen that the actions are cheaper or maybe more predictable because they are. It's always possible to challenge the patents on a national level, but we can object that this may increase the litigations, and it's possible also to have contradictory rulings and double recovery of damages that could be a cost for the third parties. Again, this is a summary of what I just explained with a table, and you can see that during transitory period, there will be 4 categories of countries. The countries where double protection is always possible, whatever the fate of the European patent. The countries, France and Germany, where only the European patent with opt-out will trigger the ceasing of effect of the national priority patent. The countries where only the unitary patent can make the national priority patent keep alive, and the countries where double protection is never allowed. And so whatever the fate of the European patent, the national priority patent will lose its effect. After transitory period is over, there will be only 3 categories, as it's mentioned on the table, and I will not explain again. I think you are all understood now. If we focus on the Netherlands, Italy, Germany, and France, this is a very simplified scheme, but you can have at the take-home message that only in Italy the national priority patent will stay alive only if the European patent is a unitary patent. In France and Germany, it's only if the European patent is opted out that the national patent will lose its effect. And in the Netherlands, it's never possible for the national priority patent to be enforced after the European patent is granted. Now, for strategic considerations, I just want to highlight some points. First, this change of laws can adjust the strategies for attacking third parties nationally, because of course, if you want to attack nationally with a patent which is not enforced anymore, it's complicated. And as the laws has changed in few countries, it's important to ensure that you can still challenge the infringers with national priority patent. So in Italy, make sure that the European patent is a unitary patent. And in France and Germany, make sure that the European patent has not been opted out. Also, at least in France, we know that it's important to know that there will be a different way of the progression of the national actions when UPC is involved in the challenge of the European patent. So you may see on this slide that there has been laws ensuring that an action filed on the basis of the national patent will become inadmissible if the UPC has taken a final decision in between about the same facts and between the same parties. Also, if 2 actions are concomitant, the French proceedings should be stayed and the damages will never be accumulated. So that for France, I'm sorry, I didn't get all the information for the other countries. And also make sure when you transfer your titles, and as I explained for France and Germany, the national and European titles are still existing together when the European patent is not opted out. So in France, at least, you should always transfer the European or UP patent along with the French national patent. You can't do them the transfer separately. And also be careful, you have to register the transfer of the European titles at the EPO along and also register the transfer of the French priority patent at the French office. If not, the titles are not opposable to third parties. So you have to make the 2 registration to ensure you can oppose your patent to third parties in France. And that's it. Thank you very much.